The congressional hearing chamber simmered with tension, thick enough to feel. It wasn't just another day on Capitol Hill. It was a collision of power, politics, and constitutional principle waiting to detonate. Governor Greg Abbott sat squarely at the witness table, radiating the polished confidence of a man who'd spent decades mastering both courtroom optics and political theater. His wheelchair, positioned deliberately in the center of the televised frame, symbolized both his authority and his defiance. With cameras trained on him from every angle, Abbott leaned toward the microphone, the picture of seasoned composure. He'd done this countless times. This was familiar terrain. Today's mission was simple: sell his latest legislative initiative, the Community Protection Act, a bill he'd been touting as Texas's answer to rising fears about safety and disorder. His opening remarks rolled off his tongue with the cadence of a practiced showman, smooth, assertive, and layered with that blend of Texas grit and gubernatorial gravitas. "We're simply equipping law enforcement with the tools they need to keep our neighborhoods safe," he declared, his voice steady and sure. Down the long table, Representative Jasmine Crockett sat poised like a trial attorney ready to cross-examine a witness. At 42, the congresswoman from Dallas had earned a reputation for two unshakable habits: relentless preparation and zero tolerance for political sleight of hand. While her colleagues shifted in their seats, whispered to aides, or scrolled through phones, Crockett sat utterly motionless. Her pen moved only to underline and annotate, not jot random notes, but build a precise record, a case she was preparing to prosecute. For 72 straight hours leading up to this hearing, she had devoured every line of the bill, tracing its phrasing against constitutional text, consulting with civil liberties scholars, and mapping how similar safety measures had quietly curtailed rights in other states. She knew this legislation inside out, perhaps better than the man defending it. Abbott's narrative had painted Texas as a state under siege, crime surging, officers stretched thin, citizens living in fear. His solution? Expand law enforcement authority, create new criminal categories, and strengthen prosecutorial discretion, all under the banner of community protection. It was classic political craftsmanship, wrapped in the language of common sense, designed to make dissent sound unpatriotic. But Crockett had read beneath the varnish. In the fine print, especially sections 7 through 12, she had found the true heart of the proposal: vague, sweeping powers that could turn dissent itself into a punishable act. Under its terms, peaceful protests could be deemed felonies. Critical tweets might qualify as criminal coordination, and police could shut down gatherings before they even began. When the committee chair looked up from his agenda and said the words everyone had been waiting for, the air in the room changed. The chair now recognizes Representative Jasmine Crockett of Texas for 5 minutes of questioning. A ripple went through the chamber. Reporters in the gallery straightened up. Cameramen tightened their focus. Even the aides along the back wall went silent. Those familiar with Crockett's style knew her 5 minutes could feel like a lifetime for a witness, and her questions rarely followed a predictable path. Before we jump into what unfolded next, make sure you tap that subscribe button and tell us in the comments where you're tuning in from. You're about to see a masterclass in dissecting political spin, piece by calculated piece. Trust me, you'll want to catch every second. Crockett adjusted her microphone with deliberate calm, locking eyes with Abbott before uttering her first word. "Thank you. Mr. Chairman," she began evenly. "Governor Abbott, I appreciate your time today and your commitment to public safety. Before we get into specifics, I just want to be certain I understand your core premise. You're asserting that this legislation is essential to keeping Texans safe. Is that correct?" Abbott nodded, smiling with polished confidence. "That's right, Congresswoman. Public safety is my foremost concern, and this bill gives law enforcement the tools they need to protect our communities." Crockett inclined her head slightly, as though weighing his words. "And you've emphasized repeatedly that this bill is about fighting crime, protecting families, and supporting police officers, values that I think everyone on this committee would agree are important. Correct?" Abbott's smile widened. "I'm glad to hear we can find some common ground, Representative." It was his first mistake. Crockett's faint smile didn't reach her eyes. "Common ground is always a good place to start," she agreed, her voice still calm but edged now with purpose. "So let's discuss what this bill actually does. Not the talking points, not the press release version, but the text of the legislation you're asking Congress to endorse." She lifted a thick binder, bristling with color-coded tabs and sticky notes. "Section 7 of your Community Protection Act introduces a new offense called organized disruption. Could You explain to this committee how you define that? Abbott leaned back slightly, his media smile still fixed. That section targets groups that intentionally disrupt public order, blocking roads, interfering with commerce. It's common-sense public safety. Crockett turned a page. Let's read the language directly. She said, organized disruption shall be defined as any gathering of 3 or more persons that creates or has the potential to create interference with normal activities, traffic flow, business operations, or public services. Her eyes lifted from the page, pinning him. Governor, under that definition, wouldn't a group of students protesting tuition hikes qualify as organized disruption? What about parents outside a school board meeting? Or workers on strike demanding fair pay? Wouldn't they all be criminalized under your law? Abbott's grin thinned. Those are hypothetical situations. They're not hypothetical at all. Governor, Crockett cut in, her tone crisp. Those are ordinary, protected First Amendment activities that happen daily in Texas and across America, and your bill turns them into crimes. The murmur that rippled through the hearing room was instant. Lawmakers who had half-tuned out earlier were now scanning their own copies of the text. Abbott straightened, trying to recover. Congresswoman, I think you're misinterpreting the intent. I'm not interpreting anything, Crockett interrupted firmly. I'm reading your words. And I'm not done. She flipped another page. Section 9 authorizes law enforcement to disperse any gathering they deem to have disruptive potential before any disruption occurs. Governor, that's the very definition of prior restraint. The Supreme Court has said for decades that the government can't suppress speech based on what it fears might happen. Abbott's tone sharpened. With all due respect, Representative, public safety sometimes requires... Public safety doesn't override the Constitution, Crockett snapped, cutting through his words. And that's exactly what this bill attempts to do. The tension spiked. Everyone in the room could feel it. She wasn't done. And Abbott knew it. Let's move to Section 11, she continued, her cadence quick but precise. This part imposes criminal penalties for using social media or other electronic communication to coordinate activities that may result in disruption. Governor, do you realize what you've done here? You've effectively made it a crime for citizens to use Facebook, Twitter, or even group texts to organize a protest. You've weaponized the basic tools of democratic participation, turned civic engagement into criminal conspiracy. Abbott's complexion reddened. Those provisions include safeguards. Where? Crockett fired back immediately. Show me the safeguards, Governor, because I've read this bill 3 times, front to back, and I've had constitutional scholars from UT, SMU, and Baylor review it. You know what every single one of them told me? That this bill wouldn't survive its first constitutional challenge, that it's an outright assault on the First Amendment, that it's crafted to do exactly what it does, silence dissent and criminalize protest. The murmurs swelled louder now, spreading across the hearing room. Abbott's voice took on a patronizing edge. Representative Crockett, I understand that as someone newer to Congress, these issues might appear... Governor Abbott, Crockett's tone sliced through his sentence like a blade. I'm going to stop you right there. Before I ever stepped foot in Congress, I spent 15 years as a civil rights attorney, defending protesters arrested for exercising their rights. I've fought unconstitutional laws just like this one in both state and federal courts. So please don't insult my experience or this committee's time by suggesting I don't understand what I'm reading. The silence that followed was absolute. Abbott's practiced composure cracked. Even some of his partisan allies shifted uncomfortably in their seats. Crockett leaned forward slightly, her voice lowering but no less cutting. Let's talk about the real-world impact of laws like yours, Governor, because we don't have to guess what happens when states pass legislation that criminalizes protest. We've seen it before. She pulled out a different set of documents. After the George Floyd protests in 2020, at least 17 states passed laws similar to what you're proposing. You know what happened in Oklahoma? Grandmother activists were arrested for gathering outside their state house to oppose education budget cuts. In Florida, environmental activists were charged with felonies for organizing a beach cleanup that included signs about climate change. In Iowa, disability rights advocates were prosecuted for blocking access to a senator's office while protesting cut-stow healthcare. With each example, Abbott's expression grew more tense. Crockett wasn't just making abstract constitutional arguments. She was showing exactly how these laws got used to silence ordinary Americans exercising their rights. But here's what really concerns me. Governor, she continued, her voice taking on a prosecutorial tone, your bill goes even further than those state laws. Section 12. creating civil liability for anyone who provides material support to activities that result in arrests under this act. Do you know what that means? If a church provides water bottles to protesters on a hot day, they can be sued. If a local business lets activists use their bathroom, they can be held liable. If a lawyer provides free legal advice to someone arrested under this law, they can be penalized. She leaned forward. Governor, you're not just criminalizing protest. You're trying to make it impossible for communities to support each other in exercising their constitutional rights. That's not public safety legislation. That's authoritarianism. The word hung in there like a thunderclap. Several journalists were typing furiously. Camera flashes lit up the room. Abbott's face had gone from confident to defensive to now visibly angry. Representative Crockett, he said, his voice tight. That characterization is completely unfair. And is it? Crockett challenged. Let me ask you directly, Governor. Under your Community Protection Act, could the civil rights marchers who walked from Selma to Montgomery in 1965 have been arrested? Abbott hesitated, clearly recognizing the trap. The historical context is completely different. Answer the question, Governor. Could they have been arrested under your law? Yes or no? The specifics would depend on yes or no, Governor Abbott. It's a simple question. Would the Selma marchers, people fighting for voting rights, the most fundamental democratic right, would they be criminals under your Community Protection Act? Abbott's jaw tightened. The intent of that march and the intent of this bill are completely— That's not what I asked, Crockett pressed. I asked if they could be arrested, and the answer is yes. Under Section 7, they were 3 or more people creating interference with traffic flow. Under Section 9, law enforcement could have dispersed them for disruptive potential. Under Section 12, the churches that fed them and the families that sheltered them could have been held liable. Your bill would have made the civil rights movement illegal. Governor, the room erupted. Republicans tried to call for order. Democrats applauded. Journalists shouted questions. And Abbott sat at the witness table, his carefully constructed political message completely falling apart. Crockett wasn't finished. She held up her copy of the Constitution, a move that had become her signature in confrontational hearings. Governor Abbott, she said, her voice cutting through the chaos. The First Amendment doesn't say Congress shall make no law abridging freedom of speech unless someone in power thinks that speech is disruptive. It doesn't say the right to peaceably assemble shall not be infringed unless a governor decides public safety requires it. It says these rights shall not be abridged. Period. She pointed at the bill sitting in front of Abbott. This legislation abridges those rights on every page. And you came before this committee trying to sell it as common sense public safety, hoping nobody would actually read what you wrote. Well, Governor, I read it. My staff read it. Constitutional scholars read it. And we all came to the same conclusion. This bill is dangerous. It's unconstitutional, and it has no place in a free society. Abbott tried one more time to regain control. Representative, if you would just let me explain the full context. The context, Governor, is that you're asking for federal money to fund a state law that criminalizes constitutional rights? And this committee would be failing in its duty if we gave you a single dollar for that purpose. She looked directly at the committee chairman. Mr. Chairman, I move that we immediately table any consideration of federal support for Texas's Community Protection Act, pending a full constitutional review by the Congressional Research Service. Several Democrats immediately seconded the motion. The chairman, caught off guard by the dramatic turn, called for order and said they'd take the motion under consideration. As the hearing continued, with other members asking questions, that image had been done. Abbott's attempt to present his bill as reasonable public safety legislation had been systematically demolished. News clips of Crockett's questioning were already spreading on social media. Within an hour, Crockett destroys Abbott waste-trending nationwide. Legal analysts weighed in immediately. Former Attorney General Eric Holder tweeted, "Repeat Crockett's questioning of Gov. Abbott was a clinic in constitutional law and effective oversight." This is exactly what congressional hearings should look like. The ACLU released a statement. Representative Crockett identified precisely why the Texas Community Protection Act poses such a grave threat to civil liberties. We commend her thorough constitutional analysis. Even some conservative legal scholars who had initially supported Abbott's bill began backing away. One prominent conservative law professor told Fox News, "I'll be honest, after hearing Representative Crockett's questioning, I'm deeply concerned about aspects of this legislation I hadn't fully considered. The prior restraint issues alone are constitutionally problematic." By evening, Governor Abbott's officer released a defensive statement claiming Crockett had mischaracterized the bill and that he remained committed to public safety. But the political damage was done. Texas state legislators who had been prepared to pass the bill suddenly weren't sure. National Republicans who'd planned to introduce similar legislation in their states quietly shelved those plans. 3 days after the hearing, the Congressional Research Service released a preliminary analysis, concluding that multiple sections of Abbott's Community Protection Act raised serious First Amendment concerns and would likely face immediate constitutional challenges if enacted. 2 weeks later, facing mounting pressure and recognizing the bill had become politically toxic, Abbott quietly announced he was revisiting certain provisions of the legislation. Legal observers understood what that meant. The bill was dead, killed not by partisan opposition, but by constitutional scrutiny, and one congresswoman's unwillingness to let dangerous legislation hide behind public safety rhetoric. For Jasmine Crockett, the Abbott hearing became another defining moment in her rising national profile. But when asked about it during a local Texas town hall, she kept her focus on the substance. "I didn't go after Governor Abbott personally. I went after a bill that would have turned constitutional rights into criminal offenses. That's my job, reading legislation carefully, understanding its real-world impact, and speaking up when something threatens the freedoms Americans hold dear." A constituent in the audience, a grandmother who'd been arrested during a peaceful protest against pollution near her grandchildren's school, stood up with tears in her eyes. "Thank you for reading those bills so carefully," she said. "Thank you for understanding what they really mean for people like me." That moment, captured on someone's phone and shared widely online, encapsulated why Crockett's questioning had resonated so powerfully. She hadn't just scored political points or created a viral moment. She defended the constitutional principles that protect every American's right to speak, to assemble, to petition their government, and to demand better from those in power. If this breakdown of how Jasmine Crockett systematically dismantled Greg Abbott's unconstitutional legislation resonated with you, smash that like button and subscribe for more in-depth analysis of the moments that matter in American politics. Drop a comment below telling us what issue you want to see Crockett take on next. And share this video with anyone who cares about protecting constitutional rights. Your engagement helps us keep covering these crucial stories about defending American democracy.